Hi, everyone. I think we're about ready to get started. My name is George McMillan, and I'm the editor-in-chief of the Virginia Law and Business Review. I'd like to thank you all for being here today. When we booked this, I knew it was Good Friday, but I didn't realize it was also Masters Friday, so I really appreciate you guys coming out, and we will do our best to get a little Masters stream going during lunch. This symposium is the product of months of hard work by our dedicated symposium team, the invaluable guidance of a number of our law school faculty, and the generosity of some of the leading antitrust scholars, enforcers, practitioners, and thought leaders who have agreed to share their time with us today. I'd also like to thank our sponsors, Cleary Gottlieb and Themis Bar Review, whose generous support made this event possible. The title of this event is Antitrust and Innovation in the Digital Age, and a lot of today will focus on the tech giants and digital platforms that have brought antitrust back into the national spotlight. These firms have leveraged economies of scale, considerable network effects, and massive amounts of data to quickly expand into more and more areas of our economy. They've delivered tremendous benefits to consumers and shareholders alike, but their disruptive effects have also posed significant challenges to antitrust enforcers. They've created new sources of market power and caused scholars to reassess 40 years of permissive antitrust policy. While these firms have shown impressive innovative capacity, they've also demonstrated an ability and willingness to stifle innovation when it threatens their continued dominance. With that being said, calls for more stringent antitrust enforcement haven't focused solely on big tech. Recent decades have seen increasing concentration in nearly every sector of our economy, and regulators have shown a renewed interest into whether concentration in industries like healthcare, agriculture, telecommunications, and pharmaceuticals has damaged competition and harmed everyday consumers. For those of you who are unfamiliar with antitrust, today should be an exciting introduction to a fascinating and rapidly evolving area of the law. Some of big tech's most ardent critics now hold key enforcement positions in the Federal Trade Commission and Department of Justice. Scholars are engaged in renewed debates about the purpose, methods, and limits of antitrust law. And after the Eras Tour debacle, Taylor Swift fans are forcing Congress and the DOJ to hold hearings and launch investigations into Ticketmaster's allegedly anti-competitive conduct. In the words of Professor Carl Shapiro, antitrust is sexy again. Thank you all again for being here today. I'll now welcome up Keith Stone, who will introduce our first panel.
Hi, everybody, and welcome to Panel 1, our first panel of the day. Our moderator today is Khushita Vasant, who is the Chief Antitrust Correspondent for MLex. She's written extensively about antitrust and mergers and covered the European Union's actions against Google, Amazon, Apple, Facebook, and many more. For our speakers, we have Aaron Panner and Josh Sovin. Aaron is a partner at Kellogg Hansen, specializing in antitrust law and Supreme Court and appellate litigation. He was centrally involved in 5 of the most significant Supreme Court antitrust victories over the past 20 years, including a case many of us hopefully recognize from civil procedure, Bell Atlantic versus Twombly. Aaron has published several articles on antitrust law and is regularly recognized as one of the country's top antitrust and appellate lawyers. Josh is a partner at Paul Weiss, focusing on antitrust investigations and litigation and counseling on competition issues. He's a graduate of UVA Law and the University of Pennsylvania and has obtained approval of some of the most high-profile, complex transactions for numerous prominent companies. Among many other high-value deals, Josh was lead counsel for LinkedIn in its $26 billion sale to Microsoft and St. Jude Medical in its $25 billion sale to Abbott Laboratories. We're lucky to have both of our wonderful speakers and our excellent moderator today. Thank you all for being here.
Hi, everyone. My name is Khushita, and thank you so much for having me here. So this is how this panel is going to be. I'm going to be asking a few questions to Josh and Aaron, but we want to make this really interactive. And I'm hoping that all of you have questions. We've reserved time for Q&A. I think there's a mechanism where you scan a QR code and ask questions, so please make sure you do that. All right, so I'm going to be setting the scene a little bit. I have been a competition law correspondent for 7 years now, and I covered EU competition law, so I tend to join the dots a little bit. So I'm going to tell you what happened last week at the ABA antitrust meeting in DC. This is the antitrust prom, which happens annually, once a year. More than 3,000 lawyers and economists and lobbyists and journalists all attend this conference. And I had a friend from the European Commission sort of ask me, what is it we are doing that, or what is it that we are not doing that we're sort of losing, the narrative here? Why has the focus completely shifted to what's happening in the US on antitrust? It's not like Europe or Germany or Brussels, France have stopped bringing competition cases. They were the first. The first Google case in Europe started in 2010. The US Department of Justice and the FTC have only recently sort of jumped on the bandwagon, but the focus has completely shifted to America and the narrative that's going on here, just trying to overturn 40 years of the consumer welfare standard. There's this progressive movement, neo-Brandeisians, and there are degrees of neo-Brandeisians. So we are going to be talking about the recent enforcement efforts in the US against big tech companies, specifically and in general, that the narrative that enforcers like Jonathan Cantor and Lena Khan have been, the strong messages they've been sending to industry that, hey, it's not business as usual anymore. So I'm going to start with talking about the FTC's challenge to the Meta within merger. That case is over, so our panelists are not constrained in talking about that case. So I'm going to start with you, Aaron. So just to sort of explain a little bit about the case, a judge in California basically allowed Meta to acquire a virtual reality app developer called Within. And the lawsuit that the FTC filed, there was a federal lawsuit in California, and then FTC had its own administrative law proceedings, which it abandoned. The FTC argued that Meta was in the process of launching its own VR fitness app, but instead opted to acquire Within and its popular Supernatural app, killing off potential competition. And in his order on the FTC's motion for a preliminary injunction against the merger, the judge concluded there wasn't enough evidence that Meta had been full steam ahead in developing a rival app, but he affirmed the legitimacy of the FTC's potential competition theory. So Aaron and then Josh, now, various FTC officials have come on the record saying, the judge's order in the Meta Within case is a toolkit that is now on the table in a way that it maybe wasn't before. And it will not be the last merger that the FTC challenges on a potential competition theory. So how is the antitrust bar responding to this warning by the FTC? Is your position that these are some really novel economic and legal theories and that they have little merit?
Well, I'll go first, and I should say that I bring an advocate's perspective to this because I represented Meta in that case. I don't think that the theories are novel in the following sense, that they actually are a throwback. And if you look at the way that merger enforcement worked in the 60s and 70s in the United States, there were a number of cases where enforcers sought to block or even to undo mergers that certainly when I went to law school, which was actually a little bit after the 60s or 70s, when I went to law school and took antitrust with Phil Arita, those cases were considered quite misguided. Because they blocked transactions that offered significant potential efficiencies and benefits to consumers, and they were blocked on very speculative grounds of what could happen if they were blocked, how life could be better in the absence of the transactions. And the FTC's within case really relied, if you look at the way that the agency briefed the case, it's very highly, they highly relied on cases back from that era. I think that certainly Meta's position was in part based on the factual finding that the judge made and about the likelihood of entry by Meta in the absence of the transaction. And parenthetically, if you look at the cases, potential competition mergers have potential competition challenges have something in common over the last 40 years, which is that they virtually always fail. And the reason that they fail is because of the basic problem that they're based on the idea, on the counterfactual of what would happen if the transaction were blocked, which courts tend to dismiss as being unduly speculative. And of course, that's what ultimately happened here. Judge Davila took the same path that many of the cases that have been decided over that period take in rejecting evidence that the acquirer might enter the market. And indeed, rejecting evidence that was, I would say if you looked at the opinions that involve potential competition, there aren't a ton. Often enforcers are able to provide much stronger evidence than the FTC was able to muster here, and it has not been accepted. So I do think, from my perspective, that what I would be concerned about with regard to the sort of analysis that went into the challenge there was the FTC really never claimed that the transaction at issue would be bad for consumers. I mean, I think that they made some efforts to show that, but that claim never made much sense because everyone sort of agreed that the whole purpose of the acquisition at issue was that Meta was trying to do something really quite challenging, which is to develop a new platform for using the metaverse and virtual reality, which everyone's heard of. Some of you may have used the headset. And they were trying to develop a new platform and additional use cases for that platform, including fitness as a use case. And the whole purpose of acquiring Within was to develop to try to take that application, it's a fitness app, and make it, promote it, make it more popular, get it to more consumers. I guess what you don't see in the opinion is any sort of effort to consider that basic point, that the fundamental incentive that Meta has is to promote this app, get it to more consumers, enhance output, to make it that platform, which is facing serious competition and has been the object of a great deal of investment, to see that, to use this transaction as a way to benefit consumers. And I think fundamentally it may be right that the fact that that issue kind of took a back seat, maybe it does reflect some, a sort of a neo-Brandeisian perspective. But I think it's very hard to figure out how to think about antitrust law and what you're trying to achieve without thinking about promoting consumer welfare. And that's been the view on the right and the left for a very long time. And there's been a great deal, economists who are considered to be more liberal have noted their disagreement with the any abandonment of the consumer welfare standard. So I've talked too long, and I'll turn it over, but I do think that it's fair to say that the Meta Within challenge did reflect a different approach by the enforcers, and not one that I would think is salutary.
So, first of all, it's great to be here. I haven't been here in a while. It looks just a bit different than when I went to law school here. These are, Paul Weiss will, or does represent lots of people in companies in this sector. These are my views, not someone else's views for that. So to level set on this, so I was a merger lawyer, a merger prosecutor at the Justice Department and the Federal Trade Commission. Professor Kovacic was one of my bosses, who's sitting in the back there. The bulk of merger work are challenges and investigations to A buying B when A and B compete with each other. So there have been challenges to mergers of supermarkets that are competing, challenges to mergers of health insurance companies, things like that. And generally what's going on is the government's trying to figure out, well, look, if that happens, will prices go up? Will output goes down? Will innovation be reduced? Who else is competing? What's likely to happen? That is 90+% of the pie chart of what has been going on to date, and that's 90% of what's going on now. I completely agree that Meta Within is different because that's the case of obviously a very large technology company we all know, buying a company that was really at the very beginning of what it was doing in a space where Meta did not compete. Now, there's a tendency to describe investigations and challenges to potential competition as a 1 or a 0. You're either on board with potential competition challenges or you're not. That's not right. That's not the way to think about it. The choice is, well, look, how uncertain, what level of certainty does there need to be before we think there's a problem, or how uncertain can it be, and there still be a problem. So, if A is buying B and B is not in the market, but B is going to be in the market a week from now, no big deal. Yeah, that's a potential competition case, but I think most people would say, yeah, let's still take a look at that and see what's up. What's going on here is trying to decide, well, what's the probability that there'll be competition down the future, down the line? How much will it be? Who else will be in the market? How long will it take? How much risk are we really willing to put on our books? What the chair of the FTC, I believe, is saying, and I'm not saying I agree with it, is that, look, I think that certain companies are so large that we want to err on the side of caution in allowing them to buy companies that might compete with them, because it's very important to protect competition down the road. And so I will err on the side of leaning towards enforcement rather than under-enforcement. That's really the choice. Meta Within is different from what has happened before because the probability of harm, I think, was quite low. The record that consumers would be harmed was quite low. This is at the very beginning of the industry, so who knows exactly who's going to come in, when and how this is all going to develop. And that, to Aaron's point, is why the government lost, because they couldn't really fill in that story. But potential competition is, has been here for a while as a basis of investigations. It will continue to be here for a while. And the way it's all going to work out in the agencies and the courts and in the private bar is trying to decide, well, what level of certainty do we need of harm? What's the magnitude of harm? How speculative can you bring, how speculative is, what level of speculation or lack of speculation is the basis for a case? And all of this, last point, will be decided much more on a case-by-case basis than through some general bright line rule.
Thanks, Josh and Aaron. I want to stay with Meta Within for a bit more. So, this challenge is part of a broader skirmish that the FTC has with Meta. There's a separate monopolization lawsuit pending in the DC District Court on basically the personal social networking services market. Perhaps you can walk us through the broader issues implicated in the FTC's complaint and the judge's order. So the FTC has gone on record now, officials have gone on record basically explaining why they see this as a partial victory. And Lena Khan recently highlighted 3 elements of the opinion that she thinks are relevant for the FTC bringing future cases. First, finding that the nascent nature of the virtual reality fitness app market with lots of new entrants could not compensate for the fact that Supernatural wielded a commanding position in the market. Second, the judge opted to apply a practical approach to defining the market using the criteria set out in a 1962 US Supreme Court case, Brown Shoe Company. And that's where Judge Davila said that applying the hypothetical monopolist test was not necessary to reach a finding that Supernatural was the dominant player in the VR fitness app market. And third, the judge confirmed that the FTC needs to only show that a firm has reasonable probability of entering the market with its own competing product, setting a lower standard than what other courts have applied. So how does this, in your practice in DC and generally the antitrust bar, are you preparing to deal with each merger challenge by the government as a battleground for this new potential competition theory?
Sure. So I think it's open to debate as to whether the decision and the standards set out in the decision have moved the law or not. Again, this concept has been around for a long time, and different people are reading the case different ways. As a practical matter, the bar and industry was analyzing potential competition issues in depth before the decision, and they'll continue to do it. This has been out there. And so what does that mean in practice? I mean, you all are about to go practice, work is coming. And so what it means is that when A's buying B, you're trying to figure out, well, look, what's B really going to do? If they're not in the market today, if they're not a competitor, let's go talk to their business people. Let's go read their documents. Let's go see what's in their emails. Let's go see what's in their chats and figure out, well, do their documents say we are about to really just crush A in the market? In which case, well, let's figure that out, what that means. That is a relevant analysis. It is very fact-specific. The skill and the art is actually trying to figure out often what's happening in the real world rather than what the case law says and what the economics may say. And so that's a live issue. It will continue to be a live issue. It matters more at times in faster moving industries than slower moving industries. So it is absolutely the case that the bar and industry are taking the chair at her word, which she's quite sincere that she thinks this is an important issue and are taking it seriously. But it is not, I believe, fundamentally altering what people are doing or altering risk calculations when people look at transactions, because it has been an important issue for a long time.
Yeah, and I'm sure Josh's perspective on that, because of the nature of his practice, is much better than mine. So I would say that I think that anybody who's looking at a potential transaction today has to be realistic. If it's a large acquirer, maybe this is a relatively small number of folks who would attract this kind of attention. But if you have a large acquirer, you have to be concerned about the risk of challenge in a way that was not true a few years ago. And I think about like Visa Plaid, that transaction got killed because of regulatory attention. And the thing that Josh would, I'm sure, agree is that the way in which enforcement um, puts an end to mergers is not so much through winning cases. Enforcers, it's not when the enforcers win the case, it's the challenge. And there's a lot of different ways in which what you'll see when you're in practice, depending on your industry, there's all sorts of obstacles that enforcers can put in the way of transactions closing. And now, of course, you need to deal with international enforcers. And the reality of the way that these transactions work is they can't be on ice indefinitely. And so simply challenging transactions raises the bar for future transactions. It makes companies more reluctant to go through with them. And that, I'm sure that the current FTC and DOJ would say that's a good thing, that there should be greater caution, and we're not seeking to promote mergers. We are skeptical of them. Others might say that it's that to the extent that this is discouraging mergers that are efficient and potentially promote the target in a way that they couldn't achieve on their own. That's unfortunate, and there's a lot of debate, frankly, about how this works. I would say that, Josh makes a really good point that for the mine run of transactions, but where the main concern is horizontal, I assume the analysis has changed less than in circumstances where the transactions are primarily vertical, that is between entities that are at different levels of the industry. I think that those are facing much greater skepticism. There is some irony to the fact that this really didn't start with the current administration. It actually started with the last administration. There was the challenge to AT&T Time Warner, which was the first vertical merger challenge to be litigated in the federal courts in a long time. The Department of Justice brought. And the current Meta case, which the FTC is pursuing, was not brought under the current administration. It was brought under the last administration. Now, I think that, I have a view about where, if you think about Section 2, as opposed to Section 7, so most of you, I'm sure, have had enough antitrust law to know that when you challenge a prospective merger, you use Section 7 of the Clayton Act, and you basically are making a predictive judgment about what the impact's going to be. Section 2 is about, is used to challenge monopolies and monopolization conduct. It can be used to challenge acquisitions that have been closed, but it can also be used to challenge all sorts of other conduct. And when I was a baby antitrust lawyer, everybody thought about Microsoft in the Section 2 context, and to a lesser extent the phone companies, which were my clients. But and today, when I think about enforcement efforts, there are two companies out there where the monopoly, in my view, raises serious concerns about impact on overall innovation and competition, because especially in the United States, Apple is an unbelievably powerful company, and internationally and in the United States, to a lesser extent, Google. They have, and in certain domains, to a great extent, Google. And I think that it's legitimate and appropriate for enforcers to be thinking about, okay, where, this isn't a merger issue as much as it is a Section 2 enforcement issue, but, can enforcement improve the prospects for future innovation? Is the current structure inhibiting innovation, which was really what was going on, right, in the early 2000s, late 90s with Microsoft. There was serious concern that Microsoft was, because of its dominant position in operating systems, suppressing innovation in important parts of the economy. Apple's in that position now, Google may be in that position now to do something similar, and so there's a serious question. I think when you think about a vertical merger and the unilateral conduct of companies that are really simply providing services or or even in the case of Meta, really, it's just an entertainment product. The attention that enforcers have to that, I find a little paradoxical. But I do think that there's room for thinking about the ways in which companies that may have a significant position as a platform, whether there are acquisitions in that area that may block potential innovations that could challenge the underlying dominance of the platform in ways that would be important for promoting innovation, which is a little bit off the topic of your question.
Oh, those are great points, and I would love to stay on Meta within, but I think you've mentioned Google, so that kind of segues into my next question. So I know both of you have some constraints talking about Google, so let's just perhaps stick to just summarizing the DOJ's and the state's case against Google when it comes to search monopoly and ad tech, and perhaps delve a little bit into the legal theories. So for those of you who are not aware, the DOJ sued Google in 2020 under the Trump administration for monopolizing search. We are less than 6 months away from a trial. September 12th is when the trial begins, and it's going to be a long one. And then more recently, about 3 months ago, the DOJ sued Google for allegedly monopolizing the digital advertising market. And there's a noodle soup of cases. So there's a consolidated class action by a class of publishers, advertisers, and a bunch of states led by Texas that's sitting in New York, the Southern District of New York. And 8 or 10 other states have brought a similar action in the Rocket Docket in the Eastern District of Virginia. Now, Google has moved to dismiss the Virginia case, and it argues that market shares greater than 50%, but less than 70%, have regularly been rejected by courts in the Fourth Circuit as evidence of monopoly power. So anyway, Google is attacking the way the market has been defined and how much market share is seen as problematic by courts. So would you sort of just want to quickly jump into it? Who wants to start, Josh?
Sure. So I do have some constraints on this. But it's a great opportunity to make some points about what sort of antitrust policy is about and how it works. So you mentioned the Rocket Docket. So I clerked in the Rocket Docket, it's fast docket, very different than many of the other dockets. What that dynamic underscores, which is a really important one, none of this is self-executing. There's a tendency, to think about it, well, look, this person has the job or this person doesn't have the job, so that must mean this is going to happen. We're going to have more enforcement or less enforcement or different enforcement. That directionally is true on some level. Yes, there's shifts in the winds and all of that. But this is a practical discipline done by people on the ground like you. A bunch of you guys are going to go into the honors program at the Justice Department or the Federal Trade Commission or other things and actually do the on-the-ground work that determines the outcomes of these cases. The fact that people want a certain outcome does not mean it's going to happen. And a lot of what drives it is not so much the philosophical differences in how people decide to frame cases or plead cases or things like that, but how people decide to litigate cases. And it's those choices that determine outcomes, particularly in front of Article III generalist judges who have a bunch of other things to do than worry about which school of antitrust thought is up or down. I mean, to take a really simple example, you mentioned the consumer welfare standard. and sort of the customer standard. And the idea is, well, look, we care about customers and consumers. And so their views should really matter in litigation, and they do. But it proved very difficult for the antitrust agencies to base their cases on customer testimony. It was tricky to do. It's hard to prepare the witnesses. You don't have a lot of control over them. What proved to be far more effective was fantastic cross-examinations of the defendants' executives. That if the defendant's stories couldn't hold up under cross, then, well, judges became really skeptical, regardless of where they fit on the ideological spectrum, about the robustness of the party's defense. Conversely, if they thought the party's executives were telling the truth, then, well, that tended to win out, often regardless of which theory you were litigating. So you mentioned, the motion to dismiss and the like, and so that's on issues on market definition and market shares and all of that. And what that gets to, briefly, is that this is not a hard science. There's a tendency to package antitrust as if it were physics or chemistry or things like that. It's not. People have come up with sort of, and that means, by the way, if you haven't taken economics or statistics, do not be deterred from going into the field. You'll be fine. What's going on there are rules and structures that are designed to deal with imperfect information. So, for example, on the market share threshold, there's cases out there which say in order to be a monopoly, you have to be north of 70% or whatever percent, and that's what's being litigated. That might be right, it might be wrong. It's just sort of a rough guidepost that you could have 100% share in a brand new product or service that you created here, but if it's going to go away in 6 months, then you're really not a monopolist. Conversely, if you've got 100% share and you've had it for 20 years, then, well, maybe we should think about that. Your market share looks pretty durable and you might have some market power. So all of that is what's going on in the pleadings in that case, and we'll see what happens.
So Josh's comments are very interesting to me because I will give a slightly different perspective with regard to where I think antitrust law went over the last 20 years and why absolutely right, everything that Josh said about the difficulty of trying to come up with rules. But I actually think that one of the things that's appealed to me about antitrust as it developed through the 80s and 90s and into the 2000s was that it was, compared to many other areas of law, at least, of course I got to know it better, so maybe if I were in other areas of law I would see the same thing, but it felt like it was built on a pretty robust intellectual structure. And to the extent that I and my colleagues had success in terms of achieving good results for clients in some of the cases that I immodestly highlight on my webpage, it was really because we were able, I think, to translate some pretty basic ideas about what antitrust law ought to be promoting at bottom. And again, it's consumer welfare standard is the shorthand. And there's disputes about exactly what that consumer welfare standard means. Don't get me wrong. There's plenty of fights about exactly what that is. But nevertheless, sort of the basic notion that antitrust law is about promoting competition for the benefit of consumers, and that considerations of efficiency and efficient allocation of resources and promotion of investment and all of those things matter. And there are certain considerations that kind of don't matter. And so, as one of my partners says, like, from the point of view of public policy, it may be a really lousy idea to have people drink a lot of sugary soda. But from the point of view of antitrust law, you want to promote as much sugary soda as you possibly can if that's what people want to buy. Now, maybe there's great great areas of, public policy where we'll, regulate these things and we'll deal with these problems. But for antitrust law, it's really kind of simple. Like, we just want to promote higher output, lower prices, greater innovation, greater quality, all those things. And if what you're doing is promoting that, good on you. And if what you're doing is discouraging that, it's bad. And that sounds sort of, maybe that sounds like obvious, maybe that's what you've learned in your antitrust classes, that of course everybody agrees with that. But fundamentally, there is a question now about whether that's the right way to look at it. And so I think that it's going to be very interesting to see to what extent, I think courts continue to find the clarity of the economic focus of antitrust law helpful, and sort of, and it's pretty deeply ingrained in the structure of the law as it exists today, because judges have found those ideas to be very easy might not be the right word, but those ideas are robust. They solve a lot of problems. They help judges to think about the cases. And again, Josh is exactly right. Like, the typical judge is not Richard Posner, right? I mean, the typical judge is not an economist, not sophisticated about math and statistics or whatever. And so, the success that you have in terms of translating what can be complicated and subtle ideas into sort of pragmatic legal arguments, I think that's key. But I do think that it's an important question to try to see what happens, whether those ideas, which, as I say, I think have been, intellectual pillars for antitrust law over the last 34 years, whether they're going to be have the same force over the next 20, I think is a really interesting question.
So I'd like to pick up on that briefly. I agree with every word of what Aaron just said. So we're in a world, obviously, of hyper-partisan debate, politicalization, and all of that, and the like, and our politics are really disrupted. If you're looking for an area of massive bipartisan consensus, antitrust is actually it. That's not the headline you're reading these days, but the policy has been enormously stable for 30 or 40 years. I have worked for people of every political sort of brand. Outputs were largely the same. They did not differ very much from the Clinton administration to the Bush 43 administration to President Obama's administration to even the Trump administration. It's not all that difficult, all that different at all. And that's because the big picture here is that what antitrust does is it deters a lot of conduct that nobody wants, left, right, or center. It is not in anyone's interest to have durable mergers to monopoly or price fixing, because then what's going to happen is you're going to have government regulation of output that no one really wants. So it's actually all pretty stable. Now, what's being tested here a little bit is whether you can nudge it to do a little bit more than it has in the past. So with respect to tech, the question is, well, look, should we err more on the side of enforcement than under enforcement, and being willing to live with greater uncertainty of outcomes when we make decisions? Should we do more in the labor markets, et cetera, et cetera? We'll see. I mean, thus far, and this is not a critique at all, enforcement decisions, with a few exceptions, have been largely predictable. A lot of what the agencies are doing is exactly what they have done before. And, again, we'll see what happens if you can sort of nudge it 5 yards one way or another. But I think the overriding theme continues to be that this is a stable policy with a lot of support across the political spectrum.
Thank you both. Both of you are doing amazing jobs as panelists, preempting all my questions. So We've got 10 minutes. Let me know if we've got questions or not. But I hope you folks are taking notes, because what you're seeing here is a less formal and highly philosophical form of what an argument in court is going to look like. But I just want to pick up on certain points both of you made. And, it's been 44 years since a US president included the word antitrust in his State of the Union speech. So if any of you heard the speech back in February, it was in 1979 when Jimmy Carter used the word, need for more antitrust enforcement, and then it was this year by President Biden. So just to keep things a bit more high level, and not to discuss fact-specific matters, the enforcers at the DOJ and the FTC talk about leveling the playing field across business and labor markets, and they talk about people being able to chase and fulfill the American dream. There's been too much focus on technocratic governance. So what are the implications of, this shift in discourse in the near and long term? You're right, Josh, when you say that antitrust is bipartisan. But it's also a deeply polarizing debate on what the right way should be. So who wants to go first?
I'm bad at the big questions. So, it's funny. There's two things that were said this morning that I really disagree with, and I think you've seen it. One is that antitrust is sexy again. I mean, not true. And the second is that this is like an oral argument, because it's not. Because in an oral argument, you have to answer the judge's questions. And Khushita asks these really hard questions, and then we answer something different that we can actually respond to. But I will say about this, I mean, I think that for those of you who are kind of interested in sort of seeing an encapsulation of where the debate is, I think it's worth reading Lena Khan's argument about, not argument, but Lena Khan's article about Amazon that she wrote when she was in law school, which, in addition to making us all feel bad about the fact that she wrote this like 70-page law review article that made her famous while she was in law school, it is a very interesting sort of summary of how people are thinking about trying to, this neo-Brandeisian idea, which is, shouldn't antitrust be taking into consideration values that are, broadly speaking, ones about how the economy ought to look, that have not been included in the way that antitrust law has dealt with problems over the last couple of decades. I think that, she makes the case, and those arguments are kind of, I think that because of where the doctrine is right now, they kind of are getting snuck in to the way that, advocacy is happening. But it's worth, kind of, if you're trying to figure out what's the fuss about, that article is worth reading to see kind of, it's a little bit of, I think it's interesting from a, doctrinal intellectual point of view, but it's also a little bit of a cri de coeur for her or for, that movement about how antitrust law ought to take a somewhat different approach. So it'll be interesting to see.
So I think what's going on, the reason you're seeing antitrust mentioned in the State of the Union is it's part of a broader political and economic narrative of change, disruption, and just transformation. We're in that time, and this produces very stressful, understandably, outcomes for lots of people. And people are looking to all sorts of, as it should, and people are looking to all sorts of policy avenues to try and bring some coherence and order to our economics and our politics, and antitrust is one of them. And it's an important one. In terms of equality of outcomes, I think that depends on what you mean. What it can do, and what it's been good at, not just in the US, but globally, is promoting a culture of competition, reducing entry barriers, reducing regulation that favored some and not many, and all of that. It's good at that. And it can't do that all by itself, but it will continue to do that. What it is not equipped to do, in my view, is produce equality of outcomes. Equality of outcomes are very important in many areas of our politics and our life. I mean, people views differ on that, but there's a lot of consensus on those sorts of things. That's not what antitrust is good at. It doesn't have the resources, it doesn't have the capability, and candidly, it involves a lot of fluctuating political judgments that are often better left elsewhere. But in terms of robust sort of promoting of markets, lower entry barriers, and less regulation, it's good at that. I think people are looking to that as things change, and I think it's going to continue to do that.
Thank you. So I have 3 questions here, and we're sort of running out of time. So I'm gonna, if you've got questions or panelists are here, you probably want to take it up with them offline. But on topic, do you feel that this administration's focus on big tech has come at the cost of enforcement in traditional markets? Should the government focus more on the price of eggs or concert tickets instead of how many ads we see on Facebook or Google?
So that's a great question. I mean, to put this in real world terms, I don't know. There's roughly between these agencies, 500 lawyers, maybe a couple of hundred economists who are doing these things. We've got a $20+ trillion economy. That's a lot for less than 1,000 people. I'm not going to say that focusing on tech, that they've allocated too many resources to that or not. That's, we'll see how all that plays out. I do think it is true, and I know for a fact that the women and men at the antitrust agencies who work really hard and are not in the headlines do continue to do a lot of work in other sectors that isn't getting the headlines, but it's very important. I get questions all the time about the healthcare markets, the energy markets, the transportation markets, and the like. So it's a difficult, like everything, it's a difficult set of choices to make about how to allocate scarce resources. And I think the headline is that the work beyond tech continues to be done.
Yeah, I just add 2 points to that. One is that when you think, I think that the focus, does relate in part to the enormous economic impact of, if you think about a company like Apple, how big it is, how much of the economy it touches. I know that, most of you are on your phones when I'm speaking, so that, no, but seriously, it's a huge, if you think about how much of your life Apple touches, it's pretty astonishing. And so to have a enforcement focus, trying to figure out, is this a problem? Makes sense. Because if there's a problem, it's a big problem. The other thing that I would just say is that, one of the great things about U.S. antitrust enforcement is it's not just the enforcers, it's private plaintiffs too. And there are a lot of areas where, again, they're not in the headlines, but there are cases, just thinking about, cases that my firm has touched that, involve things like automobile dealerships and chicken and, pharmaceuticals. There's tons of litigation in the private sector over pharmaceuticals. Healthcare, both private and state enforcers have deal with that all the time. So I think, balance is always tricky, but there is stuff going on that may not, get the, as Josh says, get the headlines.
Okay, I'll take one more question. We've got 4 now. I'm sorry to the 2 individuals whose questions I can't ask. Is it fair for courts to allow for more tenuous theories of potential and future competition in digital markets, given these markets' capacity for rapid disruption by new entrants?
I think that as a practical matter, judges try to apply the same standards, focusing on the very specific facts of the industry in question. It is very difficult, notwithstanding that people try, to draw a straight line from one decision to another and be able to continue that line out very predictably. So really fast example, picking up on some of the policy questions you've raised. So I spent 2 years working for T-Mobile and Deutsche Telekom on the Sprint merger. So that's a merger where under the market share thresholds and the economics, the government had a strong argument. Well, you're tripping market share thresholds, which should say there's an issue here, and you should stop it. What drove the outcome in the case, some people were quite critical of it, is a very senior judge, a judge who was over 70, had been on the bench in the Southern District for a long time, said, I understand that, and I'm going to grant the government their presumption that the transaction is likely to reduce competition. They sort of have met their initial burden. But I've looked at these other factors in terms of how you combine spectrum, and I've listened to the executives testify, and I find them very credible, and I think about how they might respond to AT&T and Verizon, and I think on balance, output is going to go up and price is going to go down because you're producing a stronger company with more scale and all of that. So that's one example of what I think is the right way to think about it. Yes, there are these standards and rules of the road, and they predict outcomes in many cases, and I think judges will try to apply them in tech and other things as well pretty much equally. But this remains a very fact-specific discipline, and that part of it will always matter, whether it's tech or something else.
Yeah, I mean, this strikes me as one where predictions are hard, especially about the future. I think that what enforcers do with regard to some of these issues that relate to entry in digital markets and how they deal with the fact of rapid technological change, those are going to be important issues that are implicated by some of these pending cases, including the Google cases. And it's going to be really interesting to see, which arguments gain traction with judges, how they think about it. And, antitrust is a common law discipline. It's one of the things that's really fun about it. And, every decision, is going to, moves the law a little bit, and some of them have influence, some of them, other judges look at and don't find as weighty. So it'll be really interesting to see how, in a world that has obviously introduced all sorts of structures that didn't exist when a lot of these antitrust cases were written, how the courts apply them and think about these questions, because I don't think anybody can tell you this is how it's going to turn out at the end of the day.
So thank you, Josh and Aaron. I wish this was a proper 2-hour panel, sort of like a feature film. I have so many questions based on the thought-provoking remarks both of you have made, but unfortunately we're up. So thank you everyone for your questions and for being such an attentive audience.
All right, thank you, everyone. We're going to take